This podcast is published solely based off the interests of Jacko Law Group, PC, and in no way be construed as legal advice. The opinions shared reflect those of the authors and not necessarily the views of Jacko Law Group, PC. For more specific information or recent industry developments or situations, you should seek legal opinion or counsel. You are hereby notified that any review, dissemination, or copying of this message and its attachments, if any, is strictly prohibited. These materials may be considered attorney advertising in some jurisdictions.
Welcome to Jacko Law Group's Regulatory, Compliance, and Corporate Law podcast. I'm Jeremiah Baba Pagano, attorney at Jacko Law Group. We've created this podcast to break down complex regulatory, compliance, securities, and corporate law topics for business owners and professionals like you. Today we'll be reviewing some of the most common business ownership structures. Working together with an attorney at formation will save you significant struggles later. There are 3 areas that you must see eye to eye on with your legal counsel. These include your needs, your anticipated capitalization and fundraising, and the ultimate exit strategy. Let's quickly discuss. Your needs and goals generally should drive everything in your business decision. Also, before you embark on any type of major business decision, you must ensure that your financial situation is solid. Whether you have enough capital or you may need to raise funds, this research cannot be an afterthought. Lastly, what is your exit strategy? Some only put energy and thought into the formation of a business venture, but they fail to make the exit strategy part of that process. Again, having legal counsel to guide you through these areas is critical. Now let's get into some of the most common ownership structures for non-professional entities. These include sole proprietorship, limited partnership, a limited liability company, or a corporation. Sole proprietorship is the easiest form as it does not require any filings with the state. However, the biggest disadvantage is unlimited personal liability, meaning you can be held personally liable for debts and obligation of your business. In a limited partnership, there are 2 types of partners, the general partner and the limited partners. The general partner has unlimited personal liability for the debts and obligations of the entity itself. However, limited partners do not and cannot make management decisions for the partnership. They have limited liability, meaning they are not liable for the debts and liabilities of the partnership itself. An LLC is arguably the most popular choice. This is because they provide limited liability for its members, but are much more flexible in their management. An LLC can be managed either by the members themselves, where they have a say in the decision-making, or the members can appoint one of their members or a third party to act as a manager. Corporations are considered legal business entities separate from their owners, officers, or directors. They allow for a more formal method of management through the use of a board of directors and executive officers. You should also note that it is often easier for a corporation to raise money through sale of shares, and only a corporation can be publicly traded. Determining the best ownership structure is a complicated decision in the M&A process. Peace of mind can be more valuable than costs of any acquisition. Make sure you check out part 2 of this podcast. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or find us online at jackolg.com. Thanks for listening. We hope you have a great day.